The Tenczar family bought their dream home in 2017, excited to live next to Indian Pond Country Club in Kingston, Massachusetts, about 40 miles outside Boston. Not included in the deal, the hundreds of golf balls they say have now crossed onto their property, breaking many windows, denting siding, and turning what they say was their dream home into a nightmare. The family sued the club for trespass over the continual bombardment, and a jury granted the family $3.5 million for damages and emotional suffering, with interest and additional damages. Well, it came to almost $5 million. So let's swing through the merits of the case in tonight's legal discussion with criminal defense attorneys Molly Parmer and Bob Bianchi. Welcome back, you two. Good to see you.
Good to see you, Shannon.
Okay, so the complaint from the homeowner said had the Tenczars knew of the conditions, they would not have purchased the property. Molly, should they have known?
Well, probably they should have, but their argument, which was one that prevailed in front of this jury, was that they didn't know the quantity of golf balls. It wasn't that they were surprised that there were golf balls, but that there ended up being over 600 that hit their home during the course of these 4 years.
Yeah, and we get this picture, we're told that the kids in the neighborhood had to play with helmets when they would go outside to, play wiffle ball or whatever. They would wear helmets so they wouldn't get hit. Bob, you know what it's like to actually get hit by a golf ball, so you know the damage can be substantial. However, this attorney for the country club told the Boston Globe that he's confident they're going to win on appeal. He says, "I'm extremely confident this injunction will be struck down." John Fleming, in my opinion, as a matter of law, the verdict of $3.5 million for alleged emotional distress is against the weight of the evidence. The jury thought otherwise, Bob.
Yeah, and jury verdicts are they're rarely disturbed when it comes down to damages. It has to be unreasonable. It may be on the high end, and I don't dispute that. But I think what the jury did is this is a $750,000 house. This has gone on for a number of years. There's stories of golf balls breaking through glass and glass shattering into the children's room and onto their toys. They couldn't use their property. They tried to abate this with the company, and the company refused to do it. And by the way, they also sued the people that sold the property to them, as well as other individuals, saying that you never let us know this when we bought this property, and every time we went to see it, everything looked hunky-dory. But if you look at the house now, it's just pinged up with golf ball hits, windows broken. So they were deceived both by how they were sold the property, and then these people refused to abate it. So I think the damages, people kind of fluff this off, but when you're sleeping or you're not able to sleep at night because you're worried about your kid's safety, you can't go outside, you're worried about getting hit by a golf ball, you're worried about your investment going down the toilet because nobody else is going to buy this property because of the condition it's in. I can see a jury saying $3.5 million, and I don't see an appellate court substituting the jury's judgment, this is the standard that they use, for their own unless there was something outrageously done in terms of the money.
Well, so the attorney again for the club, John Fleming, said to the Boston Globe, "It is not true that the golf course didn't do anything. A suggestion that we were completely unresponsive, I don't think is accurate at all." Now, Molly, that leaves a lot of room for interpretation about exactly what they did, but he said they were responsive.
Right. I mean, he did say that. But at the end of the day, what's interesting to me about this case, if you break it down, this couple got $5 million, and they said over 600 golf balls hit their house. If we break this down mathematically, what that means, let's say it's 700 golf balls. That's over $7,000 per each golf ball. Okay? So, I mean, yes, shattering the windows, a bit traumatizing, but, I would take it for $7,000 per ball.
I was told there'd be no math in law school, which is why I went there. Okay, so finally, the plaintiff said on this, when it hits, it sounds like a gunshot. It's very scary. We're always on edge. It's been emotionally taxing on us. It's going to be on appeal now. Bob, very quickly, a final word to you.
First of all, the verdict was for $3.5 million. The 1.5 is prejudgment interest that happens in every case. Hey, listen. I've been hit by a golf ball, okay? Thank God I wasn't hit in the head or whatever. It's no joke, seriously. It'll drive you right down to the ground. And so this was a serious case, and it represented a serious danger of serious bodily injury or death of these individuals for years, and they did try to correct it. They sent letters, they had lawyers involved, and nobody abated or corrected it, so they were forced to file a lawsuit.
Yeah. We'll see on appeal. Molly and Bob, thank you.
Thank you, Shannon.
And some good news.